Hey everybody, this is Jonathan Ginsberg. It is now 8:45 Eastern on Wednesday, February 25th, 2026. Hope you're all doing well. I'm doing great here in Atlanta. It was actually kind of warmed up a little bit, which is nice. We had some very, very cold weather the last few weeks, but today was actually kind of in the low 60s, and tonight was mid 60s. Had a tennis practice tonight, so that's why I'm doing this at 8:45 during tennis season. I'm going to be in daylight savings time. We're going to go to 8:45, so I'll let you know certainly when I post this. But anyway, I hope everybody's doing well. And we do have a scheduled guest tonight, Andrew Sindler. Hopefully Andrew can make it. He said he was. I'm not sure if there's a technical glitch or whatever, but we'll hopefully he'll come. But anyway, in the meantime, let's go ahead and take some questions as we always do. And of course, feel free to post your question. I've got some thoughts about some things I want to talk about. And again, if Andrew comes, we'll talk about those things because it kind of relates to some of the things that he and I have worked on together. So Karen, one of my clients here, good evening. We'll hopefully it's informative. I certainly hope it is. And I hope you're doing well. Did I find my completed function reports to be in order? I looked at them very briefly. I had 4 hearings. I got one tomorrow. I had 4 hearings this week. This has been a really, really busy week. So I'll make note to double check that because, again, I just, when I'm dealing with hearings, I just sort of have to drop everything and just deal with that. So, but yeah, I think at first glance, it looked pretty good. So, but I'll confirm that with you. Kevin Johnson. Hello, Kevin from Tennessee. Hope you're doing well. Cynthia, one of my clients. Hope you're doing well, Cynthia. This is, I know that you're become kind of a regular, which I really appreciate, and hope all is doing well. Bala 2001. Hello, how are you doing? Hope all is well. Tom GG. Hello, thanks. You're almost set. I think what you're asking about, Tom's one of my clients. We got a favorable decision. What he's asking about here is an award letter, which basically is an explanation of benefits. And I think that should be coming in the next week or so. I think, if I'm not mistaken, the money should have already dropped. So hopefully that will be the case and we'll be good. All right, looks like we have Andrew here. Let me go ahead and add him here. There you are. Hey, how you doing, Andrew?
Sorry, I was having a little
no problem. Technical issues that happen sometimes. And I'm just going to ask one more question.
Well.
Pardon?
I said we know it all too well.
Absolutely. Well, when we're doing hearings by telephone or video, inevitably Social Security has a problem, or we have a problem, and it's just one of those things. What are you going to do?
There you go.
So, all right. And I'm going to go through one more question. There's something I wanted to chat with you about
sure.
in a second, but this is Tom, one of my clients. When will you get the award letter? I think you're asking about the explanation of benefits or the notice of award. Mm-hmm. And the CDR basically would be not probably, and I think in your case, because of your age, you probably won't have a CDR, Tom, but if you do have any questions, of course, reach out to me and we'll address it. And most of the time you'll get either a short form or a long form. And my guess would be you'll get the short form and just, you fill it out. And again, if you have any questions, you let me know. So one of the things that, Andrew, I wanted to talk to you about, and something you and I have talked about a little bit over the past few months is, and I'll pose it this way. What do you do if you get a judge who has a really low approval rate? I mean, 30%, 20%.
Yep.
I had actually a case today with a judge with a 30% approval rate. And that's both fully favorable and partially favorable. The fully favorable was in the 20s, and some partially favorable. Basically, the partially favorable means that she had a habit of awarding cases but changing the onset date many times. Right. Meaning there would be very little in terms of past due benefits. So what is your approach when you see that you have, and you get that sinking feeling, you've got judge 20%? Right. What do you tell your clients? How do you approach it?
Well, it's interesting. I haven't had many of those recently, not quite. That's just pure pure luck, I guess.
Yep.
You and I know all too well, and everyone on here, if you don't know this, should know that getting assigned to a judge is luck of the draw. We don't have any say in it whatsoever. I mean, unless we had some kind of conflict of interest that would have us get reassigned from a judge we get assigned to. We get who we get, and we're not supposed to get upset, but in private we probably do.
Yep.
And for those of you who aren't aware, there's a public website that's part of the Social Security website where you can actually look up judges' statistics to determine their current fiscal year approval rate, and you can even look at their archived historical approval rates from prior fiscal years. So when I get assigned to a judge that I'm not familiar with, which does happen a lot these days because we do so many hearings remotely now across the country, cases get reassigned and transferred to different hearing offices. That's my first stop. If it's not a judge I'm already familiar with, and sometimes even if it is a judge I'm familiar with, if it's been a while since I've been in front of that judge, I might want to refresh and check what their current approval numbers might be if it's been a minute since I've been in front of them.
Yep.
And sometimes I'm pleasantly surprised, and sometimes I'm unpleasantly surprised if they were previously a high approver and they went down, or vice versa.
And I just put a couple of links to some websites that private law firms have where they have this information. I just put that in the comment section. So if anybody wants to check, but anyway, go ahead.
There actually used to be another website. It probably still exists. I don't know if it's being actively run or updated. It used to, I think it was called disabilityjudges.com, which was kind of like a Yelp review website, not just their approval numbers, but it also occasionally you'd see people, including attorneys, commenting. But I haven't been on there in quite some time because I don't know how reliable and up to date it is. But anyway, getting back to your question. So, and this sort of goes hand in hand with my preparation process with my clients. So after I do preliminary preparation leading up to the date of the hearing, on the day before, we do a final prep call to go over any last minute stuff. I make sure they're fully set, make sure I answer all their questions. And one of the things we'll typically go over, to the extent I'm able to, is what to expect with the specific judge we're assigned to. If I have experience with that judge, I can give much more detailed insight. But if it's a judge that all I can go by is their approval numbers, and I happen to see that this is a judge that's on the lower approval side, I basically have to brace my client for the realistic possibility that those numbers are there for a reason. And sadly, and a lot of our colleagues would probably concur with what I'm about to say, is that in those situations, and probably in a lot of others too, we're really not so much preparing to do a hearing to try to get the claim approved. We're preparing to do a hearing where we're preserving issues on appeal. So we're doing things and creating and preserving a record of statements and testimony and objections potentially, or motions to strike, in an effort to try to get prepared that in the likely scenario with a judge that has approval numbers that low, that the inevitable denial is going to come regardless of how strong the case realistically is on paper, that we have to sadly be prepared. That's the route we're going to be likely heading down, and we have to just know that it's not the end of the line. I mean, I have to give some reassurance first and foremost to say, look, that doesn't mean I'm not going to put forth the best 100% full effort I possibly can. I will never, excuse me for saying it, I will never half-ass it in a hearing. But if I know coming into it that I'm fighting a brick wall essentially, and we've been before our share of judges that fit that description to a T, then that's basically what I'm doing. Is I'm setting it up and making sure that I'm leaving open the possibility for clear appealable issues that I can raise either with the appeals council, or if I go beyond the appeals council to federal court. Just to give one example, I find that judges that have lower approval rates, I mean, for one thing, and I know you can relate to this, I know you and I have spoken about this at length in recent times with a judge I encountered down your way that you had a lot of experience with, which was very helpful to me. And I know that those types of judges typically write their decisions very sloppily, or the decision writers that write them for them, and they don't really have a lot of oversight looking over it to see, hey, we better shore things up here. So I already know that's going to probably work in my favor, and it's not really something I can prepare for. It's going to come the way it comes. But sometimes with the vocational witness testimony, there are things that are clearly left undone by the judge, especially with some of the new requirements that the judges and the vocational experts have to establish during their testimony. That if I have a low approving judge, I'm less likely to try to point out any discrepancies or deficiencies that go against what the rules and regulations require in that moment, because if I do, I'm just giving that low approving judge who's already planning to deny the case most likely extra ammunition to shore things up before the decision's ever written. And whether I do it right then and there live and at the time of the hearing, or whether I do it in some kind of post-hearing memorandum or brief, I know that I'm just giving I'm paving the way and allowing the judge the extra leeway that they don't deserve, and that's only going to harm my client's case. So a lot of times I'll take the less is more approach and say, yeah, if this vocational expert gave me some deficient testimony, I'm not going to call it out right now. I'm going to let it speak for itself. I mean, to the extent I can. Now the caveat to that is sometimes you can't just sit back altogether, because there are certain jurisdictions that would say if you don't raise certain issues during the hearing, or at least before the decision comes out, you may be deemed to have waived your right to argue those issues at a later time. Now, I haven't personally encountered that at any point, at least up my way, where most of my hearings take place in the Maryland and Mid-Atlantic region, but I have heard some war stories about that. I know some of our colleagues.
One of the points to raise is we both, I know, are on the NOSCR listserv.
Yes.
And that's also a really good source. And for what we're talking about is that NOSCR, which is sort of our trade organization, one of them, they have a listserv where a lot of attorneys are pretty active, just talking back and forth, exchanging ideas. And one of the more common things on that listserv is what do you know about this particular judge? And
right.
So if I have a judge I don't know, and they've got a low approval rate, I'll go in the listserv and say, what does anybody know about Judge Smith or Judge Jones? And sometimes you'll get this, oh, he's a really nice guy, but he's nice, but he's a snake in the grass. He'll still deny your case. Or like I had one, recently where they said, well, this judge, terrible judge. And my experience is actually, this judge was actually fairly pleasant. I had a really strong case, but something that was really helpful. She only gives you 10 minutes to do your direct examination.
Yes.
Okay. So I know that. So I had my direct exam. I told my client, we're going to go really fast. I'm going to cut you off. I got to get certain things in the record just in case. Turns out it worked out. I think it's going to work out fine. But that sort of information is really valuable to know.
Right. Yeah, and it's interesting you said that specific example, because you actually did the exact same thing for me with this one particular judge down your way, who will remain nameless. We both know who I'm talking about, but your insight into what to expect, and even some insights after I got the inevitable denial I was expecting, were spot on. Really helped me. The claim is on appeal right now. I don't know what the appeals council is going to do with it, but I know I have solid arguments that this thing has to go all the way up to the federal court level. So I'm already fully braced for that. And I was able to really well prepare my client for what to expect. And I felt awful because his claim was just so obvious on paper. It was one that never should have gone that route.
What do you think I mean, this is a question I've always had in my mind. You're a Social Security judge. Your job is to look at claims. You have people, I would suspect that most people, and the folks here can certainly talk about this, but I suspect most people would much rather be working than sitting at home for 2 years hoping that they're going to get $2,500 a month. It's not like it's a money they're going to get rich and retire. What would motivate a judge? And the other, just as a perspective, the average approval rate, I think, is 49%. It's kind of hovering around 50%.
Well, I know it's always been in the 40s, but I think it's gone up a little bit.
It's gone up a little bit, right? After the Eric Kahn thing, it went down, but at one point it was in the 60s. But now let's just say 50%. So you have a judge that, like, there's a couple I know, 12%, 10%, 20%. What motivates? Why would a judge be a judge? And have, they're so far off the standard deviation, it just doesn't make sense. What motivates someone to take a job where basically you're just causing such heartache for people that really, at least deserve a fair hearing? Or to go further than that, you've been waiting for 2 years for your hearing, and to say to the claimant and their attorney, you've got 10 minutes, you've got 15 minutes
Right.
to present your case after waiting 2.5 years.
Right.
What gives? What do you think motivates people like that?
Yeah, and those really baffle me. I don't encounter many judges that have those kind of strict time limitations, but I've heard some of the war stories, and I hear something like that, and it royally enrages me, because it's the judge's way of saying not only that I'm better than you, but my time is clearly more valuable than your time, even though I'm getting paid to do this regardless of the outcome, and your livelihood and your ability to sustain life is hanging on by a thread. It just drives me insane. So, it's an interesting question, and I've had some discussions with different colleagues over time about this. I've thought about it oftentimes over the years, especially judges that became judges coming out of practice, doing what we do every day. I've gone through the application process when they've opened up the roles in the past. I had one instance where I got really close that I think I actually had a legitimate chance for the government changed something. Long story for another day. And I kind of know what my approach would be. I'm not saying that I would just go in there, just rubber stamp, approve everything, just despite everything I've been through all the years as a practicing attorney. But it royally baffles me thinking about judges that went the route we did, as opposed to ones perhaps on the inside that were working as attorney advisors or whatever other roles, and maybe didn't have that same human element touch to what they do. So it's when I see judges that went that route and still don't seem to be landing on the higher side of the approval rates, it makes me wonder if there's truly some kind of power behind the scenes that's sort of dictating this. Now, granted, I have heard from some people in the past on the inside, and this goes a little ways back. So this is not something from someone that has been on the bench any recent times telling me this, but I remember this is somebody who actually left being a judge because they could not contend with what they were being told to do and how they were being told to do it. So there were the concepts of quotas, and really that more so goes towards how many decisions you have to knock out in a given week or month or whatever time period they're going by. But there was certainly a lot of pressure to get a certain amount of denials, whether or not there was a formal quota for that or not. I think it was more of the fear of, if you approve too many cases, we're going to scrutinize you. And we've heard some stories about some of the high approving judges that are like in the 80s and 90s that are, in the past at least, have been scrutinized. Now they claim that some of the lower, the 10, 15 percenters were getting scrutinized just the same. I don't know that I believe that so much, because they're still doing what they do. But to give a specific answer of something that a colleague shared with me, and it really resonated with me when they said this, because I never really thought of it this way, but there is so much truth to this. I don't want to lump all judges together and say that this is just par for the course, but there are definitely I think there's a good representative amount of current judges on the bench that fit this description. And the description is very simple. They're out of touch with the reality of doing hard manual labor because they've never done any in their own life. So to them, your life from childhood through adulthood consists of going to school, getting the best and highest education you can, and then going out there and doing some type of highly skilled, very technically involved, whatever type of work it is, but not in any way, shape, or form getting your hands dirty, not breaking your back, not putting pressure on your knees, not standing all day, not sweating out in the god-awful sun or freezing in the winter. I mean, the average person that we encounter, I'm not saying every single client of ours fits this description either, but far more of them than not have a strong work history doing honest to God manual labor, and they love doing it. I mean, it's not even like they're complaining about the fact that this is their lot in life. I mean, many of our clients have been doing it for the better part of 20, 30 plus years. And it's devastating to them that they can no longer do it, even though the human body just doesn't have that capability. No matter how strong or tough you are, you're eventually going to
break down.
fold.
Yeah, and I've also had people who started out doing kind of entry level type of work, doing very physical kind of work, worked their way up to more of a supervisory position or working supervisor position. So they do have skilled work. And when they're looking at their past work, it's skilled, but that 20 years ago, 25 years, or they did for 15 years, they were laying carpet, they were climbing scaffolds, things like that. That takes a toll. That definitely takes a toll. So I think you're right. Now I will say that I don't want it to make it seem like every judge is like this, because there are some really, really nice people that even if people get turned down. I mean, I've gotten denials from judges that I think are just nice people. And they're like, the evidence is not supporting this. Okay. But at least they show the courtesy to the claimant.
Exactly.
Of okay, I recognize that you are here. I give you even though I can't approve you, at least I respect the fact that you've worked hard. And, there's just not even, and I suspect some of the judges realize that it's not so much the person's not disabled, the evidence just isn't there. And if they approve it, I've had judges say to me, if I approve a case without evidence, then it's going to get reversed anyway. So we need to get the evidence in there. All right, let me stop. We'll come back to this second. I want to get to some of these questions here.
Sure.
And then we'll come back to that. Just so we got a couple of people that just want to say hello. Rodney, one of our old clients, Christina, who's a regular here. Christy, who's a regular here as well. And then, this is Rip here. Does it surprise you that SSA hasn't made any new rules that are pro-claimant? No, it doesn't surprise me at all.
Not in the slightest.
We had this golden era of about 8 months where Martin O'Malley, commissioner, and he got a few things come through that was actually very beneficial. But he's gone, and the new guy, I don't really have any sense of what he's all about. Frank Bisignano, he's also, I think, the head of the IRS. And I know he's very much about efficiency. I don't get the sense he's, mean or a somebody who wants to cause people harm. He's very much about efficiency. And of course, they've cut the staff by 30%. It's a really, it's a really tough job to kind of keep, and they're very focused on metrics. How long it takes for the, 800 number to be answered, how long. And of course, we're focused on getting these cases processed, and taking 10 months or 12 months at initial and 12 months at recon. That's a bigger problem. Yeah, that's a bigger problem there.
No question about it.
Okay. All right. So here's a question, and you have a take on this. Does a remand, and this would be from the appeals council or the district court, increase the odds for approval? What's your take on that?
Interesting question. And let me come at it actually from an interesting perspective and sort of pose an alternate question to that, which I get very frequently from a lot of my clients. And the question very simply is this, because as many of you probably know, when you get a remand, oftentimes you go right back in front of the same judge that denied you the first time. And the rule, for those of you who aren't aware, is you can only go before the same judge twice on the same claim. So if the same judge has heard it twice and denied it twice, and you appeal it and get it remanded twice, the third time you're guaranteed to be in front of a new judge. So I have had that scenario play out as well. But a lot of my clients will ask me very skeptically, aren't we just going to get denied all over again? I mean, isn't the judge going to be upset that their denial got overturned and you question their judgment? And I understand why that's a concern for a lot of people. And I understand why that's the thought process as well. But I partly base this answer on experience and statistics, honestly, from myself and my practice. But I also think about it from a very different perspective, including some things that judges have actually told me directly, and not in these exact words, but it's clearly implied. And it's very simple. I'm not saying the judges are thrilled when they see that their quote judgment has been questioned and actually overturned by a higher authority. For one thing, I don't think they're taking it personally in any way, because A, this is their job, and B, they do so many of these claims in such a high volume, they're not going to know one person from the next. They're not going to have any independent recollection like that of, oh, of course, I remember I denied this claim on January 4th, 2020, and all of a sudden this person's telling me I was wrong all the way back then. No, they're going to be like, okay, just part of the normal process, move the chain along. So what I think most judges, and I'm not saying this applies to all, and probably I would say the low approvers would probably not fit into this description here, but I think the average judge, if they see that a decision they made was deficient in some way, whether it was just not supported by substantial evidence, whether it contained any harmful errors, whatever the circumstances, I think it makes them wake up and take a better look and say, what did I do wrong? Not necessarily, should I have approved this where I denied it, even though a lot of them will eventually come around to approving it. But I think they say, obviously I didn't do my best work here and I want to do better, whether it's just to do better for the claimant that's still, fighting like dogs, claimants that are fighting like dogs to get their benefits, or, just I need to shore this up because if they've already questioned my judgment once, they're going to do it again. And if I have that happening too often, then someone's going to come knocking on my door and saying, hey, okay, this is getting a little bit too coincidental that so many of your decisions, the unfavorable ones particularly, are getting overturned on remand. And something's got to give. Either you're not doing a thorough enough job, or you're coming into this potentially a little bit biased. You have a preconceived notion. We know there are judges out there that fit that description to a T. And I just think the average judge doesn't want that kind of heat potentially being brought onto themselves. So to get to the heart of the actual question, I can personally state from my experience that the vast majority of my cases that get remanded eventually do get approved. And it's not a guarantee, and I never tell any of my clients in any way. I don't make guarantees or promises like that anyway. But when we get a remand, what I tell my clients is very simple, just flat out, this is a huge step in the right direction. It's not a guarantee of anything. If it was, then the appeals council or the federal court would have actually approved it, which they rarely do. But they're saying something was off about this, and this gives us a fresh golden opportunity to go back to either the same judge or potentially a new judge and say, let's see if we can get it right this time.
Yeah.
And
I think I've seen that as well. Not always,
Mhm.
but it does come. I think that, like you said, a judge, who's getting remanded, that's,
Mhm.
and I don't think they take it personally. They realize we're doing our job to be zealous advocates.
Right.
The claimant's trying to get benefits. I don't think most of them would take it personally.
Right.
If they did, that's a problem because they shouldn't
Yeah.
take it personally.
Exactly.
And many times, if given that the district court in particular, is not going to send it back unless there is something pretty
Mhm.
significant, they're kind of saying to the judge, this case should probably be approved. Some of them pick up on that hint, others do not.
Right.
So I would say statistically, yes, it does increase the odds of an approval, but it's not anything written. It's just,
Right.
more happenstance. All right.
Right.
Julia Jones has a question.
Mhm.
Okay. This is very good question here. Should I go forward with an MRI without doctor's orders? And what we're talking about is that there are standalone
Mhm.
MRI clinics. I know
Mhm.
there are some here in the Atlanta area. $300, $400, $500, you can get an MRI for a TBI claim. Would
Okay.
that be important evidence? What's your take on that?
Yeah. Well, I mean, one thing any practitioner will say definitively is a case always comes down to the evidence much more so than the testimony, at least at the hearing level.
Yep.
And more specifically, cases frequently come down to objective evidence, and testing and imaging studies like an MRI that are very detailed, very thorough, very specific. Definitely, if they come out favorable, and I mean, it's a sad thing to say because it's basically my way of saying the more messed up an MRI makes you look in whatever part of your body is being scanned, the stronger it is for your claim. It's unfortunate because nobody wants to see that an MRI comes back and the radiologist report says that it's an utter mess, whatever specific thing is being examined. But yes, if I mean, and to answer the specific question here, Julia, I would say if you're fairly certain, I mean, because the one thing that you want to be careful about is if you get evidence that's not favorable to you, technically there is an obligation to still submit it into the record. And that goes for attorneys as well. We can't sit back on unfavorable evidence just because it could harm our client's claim. So if you're going
let me
into
actually emphasize that
Mhm.
what Andrew is saying is really important. That is, if you go get that MRI and it comes back, there's nothing wrong with you. You've got
Mhm.
mild, degenerative disc disease. You're obligated to submit that evidence, even though it
Right,
is not in your favor.
right.
Um, and as an attorney, as attorneys, we're required to do that. You, as a claimant, are required to do it as well.
Mhm.
So, you know, certainly, like, I've had people go get functional capacity evaluations with a physical therapist, or
Yep.
neuropsych evaluations, or MRIs. And yeah, it can be, you hold your breath, because if it comes back that there's nothing really wrong objectively, you got a
Mhm.
bigger problem now.
Right,
Right.
right.
Yeah.
Now, to that end, I will say, just to sort of hit the flip side of that, because I deal with this issue a lot on appeal, particularly in federal court. So there's a litany of case law across many different jurisdictions and circuits that speaks to the fact that many types of impairments, and TBI could certainly be in that category. I can't speak to that from direct experience, but I
And
deal
TBI,
with it.
by the way, that means traumatic brain injury.
Right, right,
Just so
right.
we define our terms.
Yeah, I'm sorry. I probably should have said that as
Mhm.
well. But I do see it in the realm, just to give a couple specific examples. I have a lot of clients that either have chronic migraines or fibromyalgia. Those are two big chronic diagnoses that we see as severe impairments. And they get certain type of treatment now different than they used to even just a few years back, with special rulings that came out that speak to how they need to be evaluated. So there are a good smattering, I'd say, of judges that will deny claims on the basis, at least on the primary basis, maybe not only on this basis, of saying that either there's been no imaging studies at all, or the imaging studies that were done, including MRIs, don't show anything, or they show mild, blah, 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 whatever. And there's not only case law that speaks to why that's not okay to do, there's actually medical studies that speak to specifically, like the two types of impairments I just mentioned. They're not typically going to show up or be supported by objective imaging studies. So migraines, by their nature, usually the only reason you're doing an MRI when you have chronic migraines, if a neurologist orders one, for example, they're not doing it to diagnose the migraines themselves. They're actually doing it to rule out any other possible
Right.
causes of the migraines, like, God forbid, a brain
Right.
tumor
Brain
or
tumor.
something
Right.
along those lines.
Right. A rule out. Exactly.
Right.
Exactly.
And if they don't see that, that's not them saying you don't have the chronic migraines. You're not suffering from them. They're not debilitating. They're just simply saying, hey, we don't have another cause for it. So clearly it's there on its own. And it doesn't mean it's not legitimate just because we can't see it on a scan. Because you can't see, you typically can't even diagnose pain by itself on any type of scan. You might be able to diagnose some kind of underlying cause of pain, but it's not usually going to speak to the severity and the frequency and duration of the pain you're experiencing. So to bring it back to the point of this question, if you're confident enough that you may have something going on, that an MRI would at least show something, whether it's going to be as severe as you would ideally like it to be for the purpose of supporting a claim remains to be seen. But if you're confident enough, don't be hesitant that it may not come back as significant as you want, because that doesn't mean it's going to derail your claim either, just because of that. And
Yeah.
that's one
Although
prime example.
in a TBI, what they're looking for is
Mhm.
organic, or some sort of a damaged tissue in the brain.
Right,
Where you had this brain injury, but as you said, it may come back to show nothing, but that
Mhm.
doesn't mean you're not having emotional issues. You're not having memory
Right,
problems. You're not having anger control issues, things
right.
like that, because those are, the brain is a very complex organ, and
Yep,
doesn't always have to be physically damaged to be damaged, right?
yep.
Uh, Okay, so bottom line is that I think that if it's a condition where a doctor has suggested that an MRI might be useful,
Mhm.
or there's any indication that an MRI, which is kind of a gold standard test
Yes,
in many conditions, probably not a bad idea to do that if you can
right,
afford it. And look, beyond even the disability case, your health. I mean, you want to,
right.
you want
Exactly.
to know. I mean, if
Yeah.
God forbid you have a brain tumor, or you've got some sort of organic issue there,
Mhm.
you need to know.
Right.
So, I would go beyond a case and just say you need to know. Okay,
Right.
let's go to Dan Rudloff. Says this feels like, and I put this up. I know he's being a little cynical here,
Mhm.
but his point is actually a good one, and that is
Mhm.
when we do a video hearing,
Mhm.
this is kind of what it looks like. I mean, normally what you see is four squares on the
Right.
video. It would be the attorney like Andrew or myself. You'd have the judge by video. Then you'd have another square with a phone number. It's typically the vocational witness who does not appear by video. Then you have the hearing reporter. So it's typically four squares,
Right.
not two, but
Right.
this is kind of what it looks like. Um,
Exactly.
what do you think as far as video? Do you have do you like them? Do you prefer phone? What is your take on video versus phone versus live?
Yeah. Well, I candidly, I have not done a live in-person hearing since before the pandemic.
Yeah,
I don't know that I'm ever going to go back to it. And the simple reason for that, I mean, obviously, I've gotten a little spoiled with it, but more specifically, and my practice has definitely grown a good deal in size and volume of cases, but the ease and convenience of doing of phone hearings specifically, and being able to do multiple hearings in the same day with different judges, even sometimes at different hearing offices, would never be possible if we were still defaulting to doing all of our hearings in person. I mean, prior to the pandemic, I had some difficult schedules at times, um, particularly when we were getting to those periods of time where the scheduling process changed and we didn't have as much direct control over when hearings got scheduled as we used to. It used to be they would actually call us from the
yeah,
hearing office. They'd have designated schedulers that would say, hey, we're ready to schedule the hearing for the such and such case. I could look right at my calendar and say, this is the perfect date and time. This is when I want to do it, and make sure I don't have an overlapping conflict. So I have less incidents of that, not only doing hearings remotely, but also with the new scheduling procedures. Knock wood, it's actually been pretty consistent. Now, as far as the difference between phone and audio hearings versus online video, I've certainly done much more phone hearings. And part of the reason for that, very simply, is just because my clients really don't usually have the capability to um, reliably connect from any kind of device. I mean, even if they've got a smartphone, which virtually everyone these days, even people that are getting free phones through their local state agencies or whatever, whatever they're relying on. It's not as reliable, in my opinion, to connect to an online video hearing from a phone. You really need to have a device like I'm on my laptop right
yeah.
now. That's what I use when I'm doing phone hearings. I've got my laptop in front of me connecting to the claim file in real time so that I can follow along with exhibits. I can make reference to certain exhibits. And by the way, that's another thing too. When we were doing in-person hearings, early on, they would actually give us at the hearing site a disc, a CD, to pop into a computer that the attorneys had to use inside the hearing room. And we could pull up the claim file that would be as recent as what the judge is looking at, and that would work out great. Sometime after, they actually stopped giving the CDs. I don't know why. They just said, we're not doing that anymore. But you couldn't bring in your own device unless you had some way of connecting to your own internet, because they wouldn't let you tap into their Wi-Fi since it was government Wi-Fi. So I would go into these hearings much more blindly than I do now, because I couldn't pull up a real-time claim file to reference. I would have to just make copious notes. I would usually have a printed pre-hearing brief that I had filed that I would have for reference, but it would still only tell me so much. And if the judge said, hey, counsel, I'm looking at exhibit 3F page 7, I'm like, well, that's great. I have no idea what you're looking at because I can't pull it up here. So I love the ability to be able to do that. It's easier to do it, just logistically speaking, when I'm on a phone hearing as opposed to a video hearing where I've got two different screens that I'm toggling between. And even though, like right now, if I went to a different tab on my computer and I don't see the video feed here, you're still going to see me.
Right.
But I feel like it's a little bit more distracting all around, and it's probably going to be distracting for the people looking at my screen because the lighting is going to be changing constantly. You're going to see flashes of different things, and I just find that for ease and convenience, phone hearings work well. And then to the point of, because this is something I get asked constantly, do you think there's any benefit to a hearing where the claimant themselves can be seen? And the answer to that is it depends, because I don't think there's a bright line, this kind of client with this kind of impairment and this kind of allegation of functional limitations really needs to be seen. Part of why I say that also, and I'll I'll double down and say I would argue the same thing for in-person hearings. I can't begin to tell you how many times over the years when I did in-person hearings regularly that I would be in the hearing room, and aside from taking copious notes during testimony, one of the things I would be watching adamantly is how well is the judge paying attention to my client? Is the judge even looking at my client? The judge, for reference, for those of you who don't know, the judge had, when we were doing live in-person hearings, 2 computer screens in front of them, side by side. And I don't know what exactly they were seeing on one versus the other, but they were engrossed in those screens. And no matter who the judge was, there'd always be at least a period of time where they're looking at the screen and not looking at either of us. But some judges really took that to the extreme. It was like they almost didn't know we were in the room until we actually spoke. So I've never really been swayed by any concern of the judge should see my client to get a visual of how they are, or maybe even to garner a little sympathy, seeing how impaired they may look, at least on a video screen, if not in person. And I honestly haven't really seen, statistically speaking, any difference in the outcomes or approvals of hearings that I've done by phone versus online video versus in person back in the day.
I mean, I had this conversation with a client today.
Mhm.
That is that in some ways, not always, but in some ways, a hearing can hurt you. There's your testimony at best is going to confirm what the evidence already shows.
Right.
But you can screw yourself up if you start talking about things that are, you talk about having more capacity than what the evidence shows.
Yep.
You start, you get the judge upset because you start rambling about something.
Yep.
So, in some ways, the less you say, the better. And when you're, and look, judges are not supposed to use what they call sit and squirm jurisprudence. I mean, they're not supposed to look at you and say, "Hey, you look like you're fine. Why would you be disabled?"
Yep.
But they're human beings. And so,
Right.
if you walk in there and you are, in good shape and you look perfectly healthy, that can hurt. That can hurt you.
Yep.
So, I think phone hearings, at the very least, take that element out of it. I could certainly see a situation where it does make sense for the judge to see a person and to see them struggling. But most of the time, the evidence is really what they're going to go with. And,
Right. Exactly.
Right. Telephone hearing, I think, and the other point about a phone hearing versus video, and I tell my clients this: if you're going to do a video hearing and you're using your phone, put it on a stand. The last thing you want to be doing is
smart. Very smart.
I mean, I've had people that are, they're in bed because they're in pain and they're lying back there and they're moving their phone around and it's like you get dizzy watching it. So you almost need to, if you're not using a laptop, keep your phone, prop it up against something.
Agreed.
And
just to add one additional thing, just in terms of phone hearings that I've come to discover, I think probably happens more frequently than any of us realize. When you have a judge that falls somewhere between a decent approving to a high approving judge, and that at least is going to come in, number one, with a good bedside manner, which is the one and only thing I can ever ask for with these judges, and not make my client feel like a piece of garbage and that they're on trial in front of a firing squad. And number two, actually is engaging enough that they're interested in what my clients have to say. Sometimes I find that actually doing a hearing by phone is more beneficial because the fact that they can't see my client means that they're going to have to listen more intently and focus on what my client is saying. And I certainly see examples of that with judges that tend to be, and I tell this to my clients a lot too, usually after the fact, because I don't want to get them worried about it ahead of time. Judges that tend to be more engaging with my clients, where not only are they asking questions, not just the normal script of just basic stuff they got to get through, but they actually show they listen to what the client just had to say, because the very next question branches off of what they just testified to, and they show they're genuinely interested in hearing about it, not just asking it for the sake of asking it. And I see a lot more success with those types of judges than any others. But again, I find that if the person can be observed, and if there is any tendency to prejudge it based on somebody that perhaps, like on a screen, you don't really look like you're that impaired, despite what your records say, despite what you're alleging here. The tendency to have those preformed notions of, yeah, I mean, I'll listen to what the person has to say, but I'm not going to be as convinced because I'm looking at them and I'm not seeing the portrait of a disabled person that I was expecting to. I think there's less of a tendency when they have to just focus in on listening to the person, hearing what they have to say, and certain things can still easily be quote unquote observed by phone. You can hear a witness break down if they get emotional. Many of my clients do for different reasons. You can hear if they're getting flustered or getting confused or having trouble coming up with answers to even simple basic questions because they're nervous or because they have cognitive deficits and they just can't focus in on what's being asked. And again, I just think it forces a different level of comprehension not being able to be seen.
How do you deal with how do you deal with clients who ramble? I've had this happen sometimes where the judge will say, "How much can you lift?" And we start getting stories about when they were in high school running track, and and just their whole life and about going to the grocery store, and it just starts. What do you do? How do you deal with that?
Yeah, well, I mean, a lot of it comes down to adequate prep of the client beforehand. I mean, they really have to know what the purpose of the hearing and their testimony is. So my prep process involves, I had mentioned a part of it earlier where I do a final prep call the day before. And I strategically do that because I want the last things I discuss as the most important relevant points to be front and center in their mind at a point in time close to the hearing, but not too close. So I would never do it the day of the hearing unless I had absolutely no choice and if I couldn't reach the client the day before. And I don't like to do it too far in advance either because then it might go in and out. But the other thing that I do now, and this is something that it only started a few years ago. I think I referenced it last time I was on, but for those who are on now and haven't heard me reference this before, I started a YouTube channel for my practice back. It was in August of 2023 is when I started it. And I've posted videos with PowerPoint slideshows on different Social Security disability topics. The second video I ever posted, the very first one was like an intro to Social Security 101. The second video I ever posted was a hearing on preparing for your hearing, or video on preparing for your hearing. And it's the most comprehensive, I think, of all the videos I have on there. It's definitely one of the longer ones, if not the longest. But it's so crucial because it gives all the information in one place. It's a little bit entertaining. It's one of my more entertaining videos, but also it breaks it down in a way that's so much easier to understand than if I was just rambling on for an hour on a phone call, which is the way I actually used to do this with most of my clients. And it was not as efficient as I would like it to be. So my clients can look at the video well ahead of time. Once the hearing's scheduled, they can go back to it as many times as they need to. They can pause it. They can back it up. They can make notes on what they're seeing. And by the time we have that day before prep call, they know a lot of what they already need to know that I don't have to take the time going over. So all I'm doing is highlighting some do's and don'ts of what to do during their testimony. And I think the most prominent thing I highlight is, aside from making sure you're answering only what's asked, which is, kind of witness prep 101. I mean, even when I wasn't doing Social Security work, that's something I would tell
the way
I
describe it is, if the judge asks you what you did on Monday, what you did on Wednesday, don't talk about Tuesday.
Right.
Real
Exactly.
simple. Just answer the, how much can you lift? They don't need to know a history of lift weight. Right. I can lift 10 pounds. And the other thing, and this is the way I describe it, you tell me if you do it differently. When every day may be different. You may have good days where you could lift 15 pounds and most days 5. I say, if it's a scale of 0 to 10, 0 is you're in bed, you're with a dark room, 10 is you're able to go walk around the block 5 times.
Right.
Pick a 4. Pick a day that's a 4.
Right.
And figure out what you can do. Maybe not exactly average, a little bit below average, but it's better to give an answer as opposed to, well, sometimes this, sometimes that.
Right.
Give an answer. Pick a number. How much can you lift? 8 pounds, gallon of milk, 10 pounds, 15 pounds.
Right.
As opposed to, well, sometimes 5 pounds, sometimes you don't want to do that because and the judges realize every day is going to be a little bit different. You got to give an answer. You have to give a firm answer. So anyway, go ahead.
Right. And yeah, and that's a good approach, actually. I don't think I've ever put it quite like that. The main thing I highlight well, a couple things. Number one, the main purpose and the main focus of the testimony during the hearing, once you get through all the preliminary stuff, is we need to flesh out how your impairments affect you, what your symptoms and limitations are every day, and how they impact you. And a lot of times I try to get my clients to focus in on things when they're at their worst, even if that's not the typical average day for them. But I want the judge to get a sense of, if you're expecting me to work a full-time job, 8 hours a day, 5 days a week, there's going to be at least one, maybe more than one day a week where this is the worst it's going to be. And one employer is going to be able to tolerate this. So I tell them on the worst examples of limitations and the worst days they have, give as many specific concrete examples and details as you can. That's the area where you want to flesh those things out. And it needs to be the focus on what you can't do as opposed to what you can, or what you used to be able to do. Because if you're, and interestingly, another colleague of ours I saw who posts different types of videos on different platforms as well, and some of them are a little bit short and sweet, but very much to the point. So he posted one recently, and there were some really good points that I actually pulled out of it that I might start incorporating a little bit. One of them is the sometimes dreaded question, I call, of when a judge, because I know I'll never ask this question, but the judges often do, which is, walk me through a typical day from the time you wake up to the time you go to bed. That's a killer question, because a judge that might come in more with the mindset of, I'm looking for ammunition to be able to deny this claim rightfully rather than approve it, they're looking for signs of somebody that is functioning throughout the day and doing various tasks. So I get up in the morning, I make myself coffee, I take my medicines, I make breakfast, I get my kids ready for school, I make them breakfast, I get their lunches together, I get them out the door, I'll try to do some light cleaning around the house, I'll make myself lunch, I'll let the dog out, I'll run up to the store to grab groceries. All they've done in that scenario is paint a picture of somebody that's capable of doing various things during the day without highlighting all the functional limitations they have. They're not highlighting the breaks that they have to take, the times that they have to lie down resting, the times they have to get off their feet, the times where they try to focus even just watching something on TV and suddenly pain hits and it's like, okay, I got to take a break from this. I got to turn my eyes away. I got to close my eyes. And the way the question is framed, they don't think to put it that way. So I have to try to, direct them there before they ever get there, particularly when it's a judge that I know is going to ask a lot of questions like that. And I'm not even always going to be able to anticipate what those questions are. So that's one way that I try to deal with a rambling client. The other way, because if I'm controlling the narrative by asking the questions, I know I'm not going to usually give them that much of an opening to ramble where they shouldn't. But if they ramble,
yeah.
Well, cutting them off is one thing, even though I try not to do that too much, for nothing else than to just make a clean record for a later date. But if the judge is the one that asked the question that they rambled on about, I'll typically make the notes, so in my computer file that I'm taking notes on as they're testifying to the judge's questions. If I hear something like, oh, we better come back and hit that really hard, I'll underline it, bold it, and put big stars next to it to remind me as soon as it's my turn to ask the questions, I got to come back to that immediately, and I got to rehabilitate my client to make sure there's nothing that's going to be potentially used against them, or at least that I can, again, create a good record for appeal. So
yeah, it's interesting because when I'm doing my pre-hearing, if I get a sense that, and many of my clients, we joke about it, they know that they tend to go on a little bit. And like I said, we'll joke about it, in a friendly way. I'll just say, look, if you start rambling, I'm going to cut you off, because we don't want to piss the judge off, first of all. Number two is we only have a certain amount of time. And we, if you want to start talking about when you were a cheerleader in high school, that's really not relevant to this.
Right.
And so if you start doing that, I'm going to cut you off and say, okay, let's come back to, the time you stopped working. And I think most people understand that that's why I'm doing it. But yeah, you have to be, judges, in my experience, the one thing that does frustrate them more than anything else is wasting their time, giving them information that they don't need. you go to the they don't care what you bought. They don't care that you're
Right.
buying organic.
Right.
They want to know, do you have trouble lifting up a gallon of milk? And of
Right.
course, the thing, and I'll just say this because, we're talking about testimony,
Mhm.
and I know you say this to your clients too. You got to be specific. None of
Right.
this, not very much, not very far, not too long.
Right.
You can't do that. It's got to be 5 pounds. It's got to be
Right.
17 minutes. It's got to be,
Exactly.
30 feet. You got to be very, very specific. And
Right.
a corollary to that is don't exaggerate. Men
Mhm.
in particular, it's hard, if you've been, you worked out, you were in great shape and you ran marathons, the
Mhm.
idea that you can only lift 10 pounds now,
Mhm.
it's a kick to the gut.
Oh,
But you
yeah.
got to be realistic. You got to
Right.
just say, okay, and you got to know and prep ahead of time. I know when you prep your clients, you say, look,
Mhm.
hey, look, can you look, you got 4 herniated discs and neuropathy, you can't feel your hands. You can really lift 50 pounds. You got to be realistic
Mhm.
about stuff like that.
Right. Yeah. And I do run into, not often, at least not these days, but that typical, and I don't mean to sound stereotypical or biased anyway, because I do tend to see it more with my male clients than female clients. That tough guy attitude of, it's hard. It's a hard pill for me to swallow that I can't do the things I used to be able to do. Some lean into it perfectly. Others don't really want to accept that reality, even when I've laid it out as clear as day. Well, if you want your claim approved, you better find a way to accept that reality, or at least make the judge think you've accepted it.
Yeah.
And
One thing that happened in a hearing the other day, actually yesterday, I think, my client, the way the judge would say, do you have trouble? I don't know what the issue was, lifting, a gallon of milk, and he kept saying, well, you have the problem of doing. He kept describing it as the second person instead of saying I have this problem. He would always say you, like you
Mhm.
have this problem. Well, when you can't do when you have a herniated disc, you can't do this, or when you have a back
Right,
problem. And the judge finally said, we're not talking about me, we're talking about you.
right,
So you got to say I. Don't
right,
say you.
right.
It sounds kind of silly because that's just the way some people talk, but
Mhm.
realize the judge is listening and you've got to take ownership of it. It's not
Absolutely.
you, it's I. All
Yep.
right. All right, so let's go with a couple more here. Dennis talked about and this is, we're talking about maybe a CDR, the short form,
Mhm.
which is basically a pretty simple form to fill out.
Right.
Most of the time, if you answer no to all the questions, it'll be machine read. There won't be really any issues there. Okay,
Right.
here's a good question. 4 o'clock lover. I'm not going to even ask where that comes from. Right? Okay. When someone's applying for benefits, do you have to stay with the same treating physicians throughout the whole process, or can you change doctors if needed?
Mhm.
What do you say?
Okay. So, um, one thing that's kind of been the bane of our existence as attorneys is that there's a rule that, well, I don't know if we still technically refer to it this way, but it used to at least be referred to as the treating physician's rule.
Mhm.
And it was a very common sense rule. And it was in effect until I think around sometime in 2017 when they changed it dramatically
Yeah.
and it really came back to bite us. So the rule basically said previous that a treating physician was entitled to greater deference in their findings and opinions over any other evaluating physician, whether it's a doctor that Social Security sends you to see, what we call a consultative exam, or whether it's one of the state agency medical consultants that looks at the medical records but doesn't actually get to meet or examine you. And I still think to a certain degree that rings true, but they changed the landscape on us in 2017 and said that's no longer the case. Like despite the fact that a treating physician is always best situated to know the extent of how severely impaired you are and how long you've been that way, especially they've been treating you for a while. um, I still think that reigns supreme, and I play that argument up, and I argue it on appeal when I get denied in situations where a treating physician's opinion wasn't given any significant weight by the judge. But as to the question of whether or not it's necessary to stay with the same treating physicians versus changing, so what I say to that is the decision, and this is a little bit personal too, because I've been through this myself. I've had family members that have been through this as well. The decision to stay with a certain treating physician is really more of a personal decision and personal preference of what you're comfortable with as a human being, but also in terms of the care you need to be getting for whatever condition or conditions you're being treated for. If you've got a doctor that's not adequately treating your conditions, or they're kind of just shoving them under the rug and saying they're not as bad as you're claiming they are, and you know they're a lot worse, or a doctor that's just a bad bedside manner, and it really isn't making you feel warm and fuzzy when you go into their office, or their staff isn't for whatever reason, then you should absolutely be changing to a doctor or practice that suits your needs and makes you feel comfortable. And it should not be with any in any regards to either a potential claim to be filed or an existing claim that's already in motion, because doctors are there to treat you, and that's why you should be seeing them. They're not there to support a disability claim until you need them to. But prior to that, they're there to just treat your conditions, and they're there to treat you as a human. You know, I hearken back to the line from that Robin Williams movie, Patch Adams. I remember it like yesterday. It was towards the end of the movie, for those of you who've seen it, where he's arguing to stay in med school, where they want to kick him out. And he says, if you treat a disease, you win, you lose. If you treat a person, I guarantee you, you win no matter what the outcome. And Social Security does have certain rules and regulations, and I think there's case law that speaks to this as well, about, if there's a physician that holds certain opinions, but they've only been seeing you for a short period of time, they might not be entitled to as significant weight to their opinions and findings just simply because they haven't treated you for as long. That doesn't mean you shouldn't switch to them just because that could create more of an uphill battle in your claim. Because let's not forget, when a treating physician comes in to take over your care, particularly if it's someone new that you haven't been treating with for whatever period of time, they're not just coming in blindly necessarily. I mean, yes, you're a new patient. Yes, they have to get familiar, and they have to get your background and medical history and all this and that. But one of the key things that they're doing before they really get to any definitive point of diagnosing and then treating whatever you're dealing with, they've got to look at your detailed medical history in the form of medical records from treating physicians that have a long-standing history of treating you. And it's almost like that old adage of us standing on the shoulders of giants. And it's true to a certain extent, because doctors that are coming in to take over your care have to rely, at least to a certain extent, on any doctor's findings and treatment notes before them, as well as any kind of testing. We talked about objective testing earlier with MRIs and other types of imaging studies. And, they're not just coming out of left field. It's not like you're just going into them and saying, hey, this is what's wrong with me. And they say, okay, this is what's wrong with you. We're going to treat it. No, they've got to do their due diligence. And, what they're coming up with is based on a long line of what got you to that point in the first place. So
and many times also, two comments I would make. One is, there are some doctors out there who believe that if you're pursuing disability, you've given up. Mm-hmm. And that runs contrary to what they're trying to do, which is obviously make it better. They feel like the mind-body connection issue is, if you decide you're disabled, you're not going to get better. And of course, they want you to get better. So you have some doctors who literally will say, we will not participate in a disability claim. Mm-hmm. We won't help you because we think that you're putting yourself as a disabled person. That's not what we want to do.
Exactly.
So that's point one. Second point is, when you go to a different doctor, if you, let's say, for whatever reason, your insurance changed, which drives a lot of this, or you don't feel the doctor's, giving your complaints, your reports of conditions or symptoms enough weight, somebody new comes in, they're taking a fresh look at it. I'm sure you've seen this, but how many times have you looked at records over 3 or 4 years, and you look at the history, and the history that was done in 2022, in 2026, they haven't changed it at all. It's the same history. They just it's copied. Having somebody new come in, interviewing you, taking a look, like you said, at the previous records, it's not a bad thing to necessarily have a different pair of eyes look at it, because sometimes the treatment if it's not working, for whatever reason, the doctor is you're okay, but they don't want to really try to do anything that might make you worse. And that's ultimately a decision you've got to make as the patient, right? So,
And
yeah.
I will say also, just to piggyback off that too, and also sort of speak directly to the question itself. Of the two scenarios that I'm about to give, the one in this question is definitely the lesser of the two evils. Switching from a long-time treating physician to a new one at a random point in time while you have a disability claim pending, or stopping your treatment altogether with a physician that you're no longer comfortable with and not picking up new treatment somewhere else. The one cardinal sin in the Social Security disability world is not being under active care unless you have a valid reason that you can't be. And there are valid reasons. I mean, certainly insurance and affordability are two of the biggest ones.
But it's still going to hurt you. It's still going to hurt you.
It will. Yeah, no, there's no question about that. But in a situation like that, and I've certainly got some clients that fit that bill right now. Interestingly, I've got a case right now. It's a guy in his mid 30s, but I'm mostly dealing with his father because his mental health impairments are so severe that he really can't properly function on his own. And one of the many areas where he's not functioning properly is a year ago, he took himself completely out of care. Now his mental health impairments skyrocket the minute that happens, and he ends up hospitalized for long periods of time, which certainly helps the claim. But the caseworker who's assigned to the case just reached out to me earlier in the week and said, is this guy treating with any active psychologist or counselor or therapist? And I had to candidly say he's not. And the only reason he's not is because his impairments are kind of dictating in his mind that he doesn't think he needs to be, and he won't go voluntarily. We can't, nobody, even his father, who doesn't have official power of attorney over him. But I think even if he did, I don't know to what extent he could force him to do this. And I mean, those things can come back to bite you. Now, fortunately, I've got a reasonable case where, in this case, is at the initial stage, so it's not the hearing stage, but the caseworker assigned to it is working with us and says, well, then I'm going to have to send him out to be examined for a consultative exam by one of our doctors. And I'm actually good with that because I think it's going to come out favorably for him, and they're going to see he's not taking himself out of treatment because he's being irresponsible. It's the nature of his impairments.
Right. True or false? Do you think psychological consultative evaluations are typically going to come out better for a claimant, whereas a physical consultative is probably going to not come out as well? That's my take. What's your take on that?
Well, I've seen my share of what you just described. Sure. Yeah. And it's a hot button topic on my end. So I've given presentations with NASCAR and other organizations on this actual very topic of how to adequately prepare for and deal with consultative examinations. And I've developed a lot more niche experience with this in recent years because since the pandemic, I've taken on many, many more cases that are at the initial or recon levels than I was taking on before the pandemic. And I don't know what I don't know if that's purely coincidental or if there's some kind of rationale behind that, but I love that I'm getting so many more cases at these early stages because I have more control over that part of the process. When I was taking on cases at the hearing stage and those consultative exams already happened and they're already in the record, I'm kind of screwed to the wall, especially when they don't come out favorably, which they frequently don't. So I would say a big part of it comes down to which examiner you get assigned to. Now, I can certainly speak to the ones in my region. I can't always speak to the ones in areas outside my region, even though I'm taking more cases in other regions where I'm getting to learn more and more. So I'm trying to find ways, and there are some tools and methods, which we can save for another discussion another time, of getting reassigned to, or not to a specific examiner, but to get away from a notoriously bad one that's going to basically say the same thing for every person they see, that they've got virtually nothing wrong with them and they have no or very minimal limitations. As far as psychological versus physical, it really does vary. I can't say there is, any predictable physical ones are always going to go this way. Psychological ones are always going to go that way. I've got some repeat offenders up this way. There's one particular psychological examiner in general that does exactly what I just said before, where literally, and I filed complaints about this fact, every single report of any client of mine that he's seen, if I put them up side by side, other than the name and date of birth, they are virtually carbon copies of each other.
Yeah.
No matter what my client's conditions or background are. It's unbelievable. And how this guy is still doing this is baffling to me.
Yeah.
The agency is just too lazy to investigate and find someone new. But,
and what do you know? I have this question arise. Somebody goes to the, let's say, physical consultative, and they tell me, my client says to me, I was in that guy's office for 10 minutes.
Yep.
Yet this report says he did this neurological test and he did this, that. The guy didn't touch me. He was on his cell phone, barely looking at me. And, I was in and out in 10 minutes, yet he talks about all these tests. What is the best thing as the claimant? What can you do to address that? How do you protect yourself, and how do you let the judge know or the adjudicator know this is what happened?
Well, I have a two-pronged method for this. And this is actually part of the presentations I've given, and there's a video on my YouTube channel that I send all my clients to get a background and understand this. So the first thing is, every single opportunity I have, and for most of my clients this is not a problem, I insist that they take someone with them to the exam, and more specifically, I insist that that person must accompany them into the exam room and be with them at all times. And there is no rule, law, policy, procedure, anything that says they can't. And occasionally I get a difficult examiner or examiner staff that tries to push back on that. And I insist that my clients put their foot down and stand firm to say, I have consulted with my attorney. He has told me I am allowed to have this person come back with me, whoever it is, family member, friend, doesn't matter. If you refuse to allow this person to come back with me, I will respectfully refuse to proceed with this exam. And I let the caseworker know about that ahead of time so that they're not blindsided and they don't try to say my client didn't comply or cooperate. Knock wood, it has not been a problem. Even on the times we've gotten pushback, the examiner eventually folds. So that's number one. And the purpose for this person coming back, well, there's two purposes. The first one is they need to be there for support and potentially even to help them recall relevant facts of their medical history, which is it's perfectly fair and reasonable. But behind the scenes, the main purpose they're there, we don't tell the examiner that, is they are a second set of eyes and ears to give observations of how long the examiner spent with them and what they actually did and didn't do. So that's the first thing. And then second thing that sort of branches right off of that, every single one of my clients, before they go in for these exams, gets sent by me directly a questionnaire. It's either 3 or 4 pages. One is for physical exams, one's for psychological exams. And it has a breakdown of questions, mostly checking boxes and filling in short blanks. And then there's a little remarks and comments section at the end. It basically fleshes out what I expect to happen at a typical exam and what I expect is going to be reflected, whether it's accurately reflected or not, on the report. Now, this questionnaire isn't just any old questionnaire because it also doubles over as a signed and sworn affidavit, because my client signs an affirmation statement at the bottom of it on the last page when all is said and done, and then they send it back to me. This gets held in my case file until I have the report from the consultative examiner. If I look at that report and download it from the claim file and I compare it side by side with my client's questionnaire and it's outrageously off the wall, they're stating things that my client never said or did. They're stating that they did parts of the exam they didn't do. They're stating that my client had no problems doing stuff that my client reported they had a ton of problems doing. 100% the next day, I'm objection and a motion to strike that report. I'm alerting the caseworker. If it's at the ALJ level, I'm alerting the judge. And I've seen mixed results with that. I mean, some adjudicators are a little bit more responsive and reasonable with that approach. And sometimes it's a moot point anyway, because if I still at least get the minimal findings I need, particularly for advanced age grid cases, and I just need to get it to a certain RFC, I don't have to nitpick the small things, even if they're kind of important small things. But that's my typical approach, and it's worked really, really well over the years. And it keeps some of these examiners in line, especially when there is a second set of eyes and ears in that room, because they know they can't get away with some of the stuff they try to.
Okay.
Um,
All right, let's go back to some more questions. Maureen says, good evening.
Mhm.
So good evening. Rip, we were talking about the low approval. He had a 19% approval judge. Ugh, that's just a very depressing kind of thing to have happen. Christina asked everybody to leave a 5-star review. That's very, very absolutely. In fact, I'm going to put on here a place where you can do that. And by the way, since we're talking about to Christina's question, if somebody wanted to reach out to you, how would they reach out to you, Andrew?
Yeah, I'll put it in the chat right now.
Okay.
I'll put all my credentials in there for you. Wait a minute.
Okay, very good.
I have to connect.
All right.
Is it going to make me log in to do that? I thought I could put a comment on here.
Or you can just, if you just want to send it to me as isn't there like a place where you can comment to me, or private chat? I think there's a private chat. I'll just, I'll send this to you, and I can post it.
Yeah, it looks like it's just asking me to log into my YouTube account, which I can do. Yeah,
okay,
I'll just do that, and that should be fine.
Okay, and then we have a question here from Whitney Zachary. Love to know the approval percentage rates at a hearing level, Mississippi. I think, if I'm not mistaken, some of those, a couple of those links I gave you earlier, you can sort by state. Although honestly, it really only matters that the particular judge assigned to you. Like in Atlanta, there are judges with 20% approval rates, and there are judges with 70% approval rates. So the average doesn't matter if you get you get a low paid judge,
right,
as opposed to a higher paid judge. So anyway, all right. Karen Pritchett, what's the percentage of people who did not approve at an initial? What about reconsideration? Social Security does publish something called a waterfall chart. If I'm not mistaken, the last one said something to the effect of that about 30% of initial applications are approved. A lot of those are people at listing level with something, life limiting or very, very serious.
Or a clear grid case too. I've seen a lot of times that'll be one that'll get them too. But although those are still not as obvious as they should be.
The grids, some adjudicators don't really understand how the grids work, and part of the reason is we're talking about the grids, and I've got a website called gridrules.net for those who want to look into it a little bit more. Basically, if you're over 50 and you're limited to sit down, sedentary, or light work, you can be found disabled even if you have some capacity. The issue many times turns on whether you have transferable skills. And that question is one where adjudicators don't like to make that kind of call, because that's sort of a somewhat sophisticated vocational analysis where they have transferable skills. We need a vocational witness to do it. So you don't see as many grid rule cases decided initial and recon, but the listing levels are, and those are the ones that, terminal cancer, God forbid, Huntington's disease, ALS, things like that, they should be approved pretty early. So an initial about 32%. Recon, last I saw was like 18%. That seems kind of high. I always thought it was closer to 10 or 12%.
I got some interesting insight from from a supervisor with one of my local DDS offices about recon specifically, and it was actually particularly in regards to I'm trying to remember how she put it. So for those of you who aren't familiar, when you get a decision at the initial level, particularly when it's a proposed approval, this happens more often with approvals than denials. Sometimes the decision gets pulled by the Office of Quality Review, OQR, and they look at it to see if they agree with the decision that's being proposed before it goes through. So one thing I've been told is that and this is usually in the realm of decisions where they approve the claim, but they change the onset date, which sometimes has a dramatic impact on the person's entitlement to benefits. And they told me that if there's been an OQR review and they made the change, then they'd have to see something truly, truly compelling, different than what was at the initial level, not just you disagree with the decision, in order for them to make any change at recon. So it's the whole idea of rubber stamping at recon, which we see quite frequently anyway, really kind of gets doubled down on when there's been a previous OQR review, regardless of what the ultimate outcome was at the initial level. So if your claim has been subject to OQR review before it ever got to a final decision, and then you appeal it to recon, the odds of you getting it changed at recon are pretty slim to none, and mainly because the caseworkers just know if they try to change it, OQR is going to pull it again and do the same thing.
Yep. All right, so I just put the most recent waterfall chart. So according to this, 38% of cases were approved at initial. Right. Again, those are people really serious. At recon of the people who appealed, not everyone appeals, but one appealed. This says 16%, which again seems a little high to me. But again, those are going to be cases that are probably more listing level. Right. Then the hearing in 2024, fiscal 24 was 51% of cases were approved, which is again a nice bump up. It was, after the Eric Kahn debacle, it got to like the low 40s. Now it's up to 51%. But look at the appeals council. The remand, it says 16%. That seems a little bit high to me. But if the federal court gets it and they remand 63%, so that doesn't mean you're going to get approved. Just means the case is being sent back to the judge for some other
interesting point about that, by the way. And this came up. You've probably seen this too, because this has come up recently on the NASCAR listserv. So somebody posted about the context of it was someone had a federal case filed, and this is somebody that does not do a lot of federal court appeals, but he said that the attorney on behalf of Social Security with the Office of General Counsel filed a motion for an extension of time to file their response brief, and in that motion they referenced the fact of how overloaded their offices are dealing with all these federal court appeals that are happening in virtually every jurisdiction across the country, and basically claiming that they've got a volume right now of cases that they have to get response briefs out on. I want to say this person said he's got to get like 3.5 briefs done a week, and mind you, for those of you who aren't familiar,
that's a lot.
These are not 2 or 3 page briefs. I mean, these are, my average brief in federal court is easily 30 to 35 pages, double spaced, but it takes up a lot and it takes time to do. And they have to actually respond to the arguments we're making. So it's not like they're coming in prepared with what they're going to argue kind of the way we do. And for that reason, there's definitely been some speculation that one of the reasons why federal court cases are getting remanded as frequently as they are is because the Office of General Counsel across the country and all the different jurisdictions in every state just doesn't have the manpower to deal with this. So one of two things are happening. Either they're offering voluntary remands, which hasn't been happening as often, but it does still happen. I just got one recently that surprised me. I wasn't expecting it. Or they're just putting together really sloppily written briefs that are not really citing any new definitive arguments. That, like, a lot of the responsive briefs I get are very easy to take apart in my reply briefs because all they're doing is just regurgitating exactly what the judge already put in the decision, as opposed to actually responding in any substantive way to my arguments. And it makes for a nice success rate on my end. But I think that's one of the reasons why, because you're not getting that same individualized attention at the appeals council, because it's still not really an adversarial process. You don't have attorneys that are looking into it more deeply and realizing, yeah, we should remand this case, or I don't really have the most cogent arguments to make. So, and there's no oversight at the appeals council level either, but that's another story for another day.
All right. DWS says, I'm an above the knee amputee, which again suggests that he meets a listing in a wheelchair full-time, applied for SSI. And by the way, this is, people say SSI. SSI is a part of the disability program, but that's stands for supplemental security income. It's not the same as disability. A lot of people, it's like calling it Kleenex, but SSI is not disability. It's one type of disability, that's income and asset based. So again, it could be SSDI, it could be SSI, but let's just assume it's SSI. Had a consultative last week. DDS said that was the last thing they need. When can they get a decision? I would say probably fairly quickly. If you're an above the knee amputee, you meet a listing, they should approve you, within, certainly within a month.
Right.
But okay. All right. In an ALJ hearing, how much weight is given to a third-party vocational rehab evaluation from a vocational rehab expert? Is ALJ required to address this in the decision? So it almost sounds like Art of Practice says that he or someone he was representing or someone he knows hired a vocational rehab consultant, vocational witness to do a vocational evaluation. And that's pretty rare because those are expensive to get done.
Oh, yeah.
Is the ALJ required to address that? How would you answer?
So I've actually had cases. I've never personally hired an outside vocational rehab consultant or expert, but I have had cases where there are reports that are generated, usually because of some underlying case. And in fact, as a matter of fact, the one case I had with that infamous judge down your way that we've talked about before included one because this poor guy, God, this is just one of the most awful situations. So he had an underlying workers' comp and personal injury case from a third-party negligence matter. He was working for our local utility down here and was on a 12-foot ladder. An explosion occurred, blew him off the ladder. How he came out of it alive, I don't know. But he's clearly permanently totally disabled, despite this knucklehead judge that is trying to say otherwise, and we're going to fight it tooth and nail. But as part of his workers' comp and as part of his underlying third-party negligence claim, he had an outside vocational assessment done, which concluded from a vocational standpoint, not just a medical standpoint, that he's permanently disabled and can't ever work in a competitive capacity. And we submitted that as evidence well ahead of the hearing. And I think the judge treated it like a piece of toilet paper. But I think that's largely because of the judge we had. Now, in my experience, because this is few and far between, I don't frequently have this kind of evidence to offer. When I have at least a halfway decent judge, I certainly think they're going to consider it as a relevant piece of evidence. But like any piece of evidence, they're going to look for general supportability, and then the big one of all, the one I always come back to at the end of the day, consistency. They want to see if these opinions actually have a basis in reality. They want to see if there's actually evidence that exists within the file. Now generally you're going to see any other vocational evidence in the file, but you're certainly going to see your share of the medical evidence. You'll see the person's work history, and you'll see things fleshed out that way. But again, they're going to look to see how the opinions are being formulated and what's going into those opinions. No different than a medical expert or a treating doctor rendering a medical expert opinion. We're not just going to go by your finding that you think your patient is fully disabled because you say so and because you're the treating doctor. You better have something to back it up. And if your treating notes particularly don't really match up with it, I don't think they're going to give it much, if any, weight whatsoever. This particular case of mine in question that I referenced, this vocational report was not only very thorough and very efficiently done, but where the judge actually said it was not based on any reference to any substantive evidence, that nothing could have been further from the truth. I don't even think he looked at this report when he made that finding. I think he made it just to show that he considered it on paper. But the reality is, if he had taken 2 seconds to read it, he would have seen the first thing the vocational expert did was do a detailed chronology of all of the medical treatment that led up to that point, and then rendered his findings and opinions after that, taking all of that into account, taking into account the market studies and the requirements of the work he had done and the requirements of work in the economy in general. I mean, one of the most thorough reports I've ever seen, and I was so glad that somebody else paid for it, because that was not going to be conducive to my client's cause. But,
I think that most judges would at least address it, if not give it pretty significant weight, because it's almost like having a neurosurgeon offer an opinion about your back as opposed to just your family doctor. So it'd be hard to say it's not relevant. All right, so we got about 30 minutes left, so let me kind of zip through some more of these questions. All right, Whitney, this is going back to what we talked about earlier. 100% would rather be working. I think most people feel that way.
Oh, yes.
Kathy Clayton, does the DDS put a lot of weight on the CE doctor's report? Yeah, I think they do. I think that they with the elimination of the treating source rule, they can consider any evidence, and the CE evidence is usually what they rely on to deny the claim.
Yep.
Because and part of it is because the doctors many times are not talking about specific functional issues that are really relevant to Social Security, whereas many, although not all, CE reports do address some, their medical source statement that do address some functional limitations. But yeah, typically they will rely on that a good bit. That's usually a big part of it. In fact,
interestingly, I will give you the flip side of that. I have had not many cases, but I've had a few in recent times where I've had an extremely supportive CE report, and somehow it still results in a denial, and they find a way to set that report aside. Or even worse than that, this one really floored me recently, and it's on appeal right now. So my client went for a mental health CE. She's got a lot of physical problems, but she's got a good amount of mental health too. And the CE report's findings actually equated to a listing. She had marked limitations in 2 of the paragraph B criteria. So not only was the claim denied, but when I reviewed the disability determination explanation, I don't know if it was the caseworker or the consultant that screwed this up. It actually didn't even accurately reflect what was in that report. It said there's no finding anywhere that this woman has more than moderate limitations in any of the paragraph B criteria. And I just threw my hands up in the air. I'm like, then clearly we're not reading the same report.
Yeah.
And I haven't gotten any kind of response or explanation. I put in a call to a contact I have, a supervisor contact, to say that's unacceptable. And now I'm trying to convince the new caseworker at Recon not to fall into the same trap, and I'm getting to run around with her. Yeah. It's like, so the CE reports are only relied on, I think, when they suit Social Security, not when they suit us.
And by the way, and I realize this is something that your attorney will have to get for you, but if you look at typically, I think it's the A section, I could be wrong, there will be an explanation of the decision, and it may be 13 or 14 pages, and it kind of gives a summary of what they did and their findings. And that's actually really relevant, very helpful, because sometimes, like I had my case today, they found in that report my client could not do past relevant work, both at initial and recon. Now, again, the judge is taking a completely new look, but that I think is many judges are going to accept that.
Oh, yeah.
So you can get some nuggets out of that. Look, I've had a number of these cases where they found my client's not disabled because he could do past relevant work. Well, the problem is it's been more than 5 years at the time of the hearing. It was 3 years from the last past work at the time of initial determination. Well, now the look back period is 5 years. It's been more than 5 years. By definition, there is no past relevant work. They meet the grid. So you can sometimes use what they find against Social Security because things have changed.
And they make mistakes too, real fast, just to piggyback right off that. I had a case that got denied at Recon on a transferable skills analysis. It would have been a grid case otherwise, but I read the fine print, and this was back before we were getting access to the A section, before it was at the hearing level. We didn't used to get access to it that early. I pulled it up. They did the wrong transferable skills analysis. They cited it wrong to the rules and regulations. I pointed it out. I filed an on the record request. The judge granted it. Case done. Didn't even have to do the hearing.
Yeah. Or they will. And one of the things I look at is they will identify jobs using the DOT, which is a whole nother thing we could talk about. DOT is this outdated resource they use to identify jobs.
Next live stream, I think that'll be good.
We could talk about the DOT, which if you want to look at it is at occupationalinfo.org. And the big picture is this is a resource that Social Security has used for years to identify jobs. The problem is it was last updated in 1990 something. And there are jobs in there that, teletype operator and typewriter repair person and things that don't exist anymore, elevator operator, things like that. But regardless, the vocational people at Social Security or the adjudicator will decide on a job. You look at the job that they described and you look at the claimant's work history, not the same thing. They say it was a semi-skilled or a skilled job when in fact the client was doing unskilled work or very low and semi-skilled work. And again, that's another argument to make is that that decision should not be considered.
My favorite is when they don't even cite actual jobs that they claim my client can do
correct
in the DDE. So I have a lot of fun with that.
Right, they're limited. Any job in the light category they could do. Right. Okay, so Chen Ted has a 47% judge. That's right about average. That's not terrible. No. That's not terrible. So let's see. And Whitney notes the attorney needs to help the client. Yeah, I mean, part of the job of the attorney is to make sure the evidence that exists is in, and to offer advice about evidence you need. Okay, Zippy61 says hello Zippy. Says the appeals counsel is only approving 14% what they review. Some claims were remanded and appeal at the federal level. Something. Okay, I think the point that Rip is making here is why is there such a difference between what the appeals counsel is doing and the district court is doing?
Right. I know we talked about this a little before, but I think one of the big things that I'll highlight it again is there is absolutely zero oversight at the appeals counsel level. No one is looking down their shoulders to see what they are, or in many instances, I suspect, are not doing. And I can cite from personal experience over the years, from when I first started doing this till right now, I have had so many cases where I used to file, I don't do this really as much anymore, but I used to file these really detailed, fleshed out briefs that are like almost a step just below what I would file in federal court to the appeals counsel, making the same kinds of arguments with citations to the record, citations to case law, you name it. And I get back their rubber stamp denial, which frustrates me in and of itself, because the appeals counsel is not required to give you a reason when they deny an appeal. They're only required to give you the reasons when they remand the case and say what the judge did wrong.
We've denied your appeal. That's all.
Yeah, all they say is boilerplate. We consider the reasons you disagree with the judge's decision. We find no basis under our rules to change the judge's decision. Have a nice day. So I have no idea what they did or didn't look at. And I've had cases where I don't file any brief at all and they do remand it. So that's why there's no rhyme or reason to what they do, because there's zero oversight. At least at the federal level, regardless of what the outcome is, I know I'm going to get a detailed memorandum opinion from the judge overseeing the case. And I'll know, even if my arguments failed, why they failed. I don't get that from the appeals counsel. So,
yeah. Okay. Yeah, at least the federal court will give you something, with the appeals counsel,
I'll take it.
Yeah. All right. Good evening. Okay. Thank you very much. Boracua 938. Thank you. My retro channel says my case is back in federal court for the second time. Wow. The AC remanded it 3 times, 2 different judges, same pattern of errors. Records show I made 12.05B listing, which I think is mental health, should get overturned. Yeah, sometimes, I mean, you see these cases that last 10 years, 15 years.
I've got one that's going over 20 years.
Oh my gosh, it's just crazy. Yeah, it's very, very frustrating. And I mean,
we feel your pain. We definitely feel your pain.
That's right. At an LJ I think we've already answered this.
We did that one.
Yep. Okay. I've reapplied, and I'm on the initial stage. Rather face 1,000 deaths than to face an ALJ ever again. 10-year battle. Yeah, no, I hear what you're saying. It's frustrating. Okay, so I'm just saying we'll call it the Requiestry. I'm not sure what that means. Good evening. I use all information my SSD approved. Okay, great. That's the goal here. We like to share what we know. Yes. And I'm glad you got approved. You got to keep good. Then it's pretty straightforward. Keep good records and go to the doctor's appointments. Like Andrew said, you got to go to the doctor. The thing that Social Security will kill you on is if you don't go to the doctor, if there's a gap in the record.
And let me actually, since you bring that up, let me say one more thing about that. And I think I did this the last time I was on the live stream. Another key thing that's crucial with good record keeping with the doctors is, particularly with a lot of doctors nowadays that have online portals, communicate with your doctors when you're having flare-ups, even if you're just sending a message, not necessarily for the point of, I need to get in to see you because it's that bad. I mean, if it is, you should do that. But when you send messages, particularly written messages through portals, to say, I am having a really bad day, here's what's going on, and describing it, that becomes part of your record. That becomes part of Social Security's record. And even when you're going in for your exams and they're not showing the active flare-ups at those moments, which makes sense, because if you're actively flared up, you're either going to be home resting and canceling and rescheduling the appointment, or you're going to be at the hospital. But they're going to see what they don't get to see when you're in their exam room, at least from the way you're reporting it. And there's going to, again, be, I keep harkening back to this word, a consistency about it. And if the doctor doesn't have a portal, calling in, they'll take the message down. That becomes part of your record. So take advantage of that. Make logs when you can, your own personal logs or diary notes when you're having those kind of flare-ups, or you're having the types of impairments that have regular occurrences like migraines or digestive issues or anything like that. Make note of it as much as you can. That can be pay dirt sometimes.
Yeah, no, I think that having a headache diary or a pain diary, that can be very, very
absolutely.
All right. So Rip says, what about ALJs who ignore post DLI evidence like surgery, worsening conditions? All right. So what we're getting at here is, let's say that you have a date last insured, we're in 26 of 2024. September 30th of 2024 is your date last insured. That's when your insurance ran out. You've had surgery in 2025. What should the ALJ do with that? And the problem, of course, is that if you are found disabled after your date last insured, it doesn't help you any.
Right.
You win the battle but lose the war.
Exactly.
So, the times when it would be relevant would be if it's a continuation of something. Either if let's say that you had a surgery, if your date last insured is September 30th of 24 and you had a surgery in October of 24, okay, you can make an argument that condition was at the same, it was surgical need as of the date last insured. Once you get beyond 3, 4, 5 months, it starts to become less relevant. So judges aren't going to pay it that much attention. And really, one of the things that I, encourage my clients to keep in mind is, if we have a date last insured that's expired, we got to focus on what was going on in 2023 and 2021. It's hard. I mean, I can't remember what I had for breakfast most days. Much less what was going on in 2021.
Right.
And many times people will kind of slip into talking about the current, last week. You got to stay away from that. You got to, if you have a date last insured problem, you have to really, really focus on what was going on back when you had X, Y, and Z, or some, when COVID hit, or when the Braves won the World Series or something. Which it's been a couple of years. All right.
I have no room to talk. It's Orioles my way.
There you go. Okay.
And I will say, just to add to that, I have had in the last, let's say, year or two, several cases with very remote DLIs that I actually was able to get approved by the skin of my teeth, some of them, but I don't automatically give up on them just because it's a remote DLI. I mean, it can be challenging, and I'll be honest about how challenging it is if I know it's going to be that much of an uphill battle, but sometimes it's still doable.
Yep. All right. And again, we're getting close on the time, but okay. When someone is ready to appeal denial to the ALJ, should they file an attorney before filing the appeal, after they file appeal? Clearly before. You want to, appeals counsel work. Look, you should not go to a hearing without a lawyer. You should definitely not try to deal with the appeals counsel or district court without a lawyer. Get somebody early. I mean, you absolutely want to get somebody early. Now,
Social Security, by rule, if you go to a hearing without an attorney for the first time, they must give you the opportunity to postpone the hearing at least once to get one. And many people do take advantage of that. So they try to encourage it as much as we do. It's not.
Do you take appeals counsel cases for hearings that you didn't conduct? Or just
I do, but I scrutinize them much more closely. It's hard because I'm trying to piece something together that I wasn't present at. And I can glean certain things from the decision, or I can at least spot appealable issues without even knowing what happened at the hearing, just to know, this is winnable. Same thing with cases that are going to federal court that I wasn't involved in beforehand. Now, if there was an attorney that was handling it and they left on amicable terms, sometimes I can reach out to the attorney and say, hey, can you give me some insight? What happened during this hearing? Do you even have the recording of the hearing? And I'm okay to do that. But it's tough, but I won't automatically turn someone away just for that reason.
Okay. And Bala 2001 says, Andrew, they'd like you to tell us where you're at, where you're located, and a little bit more, just just basic. We don't go into exhaustive detail, but just a little bit about your practice.
I did put some information. I don't know if it came through in the chat, and
I did. I put it on the comment section.
Okay, good.
Website and your
so yeah. For those of you who don't know, I'm based in Maryland, right outside Annapolis, our capital. And I've been practicing Social Security for over 20 years. I've been a solo practitioner for over 15 years. And I take cases from initial all the way up through federal court. I handle specialized type of cases, continuing disability reviews, certain types of blindness benefit cases, which are highly unusual, childhood SSI claims, recomputations on retirement benefits. I think the only case I don't typically handle are overpayment cases. Long story why that is, but I do at least try to advise people when they come to me for overpayments. So always happy to help. I referenced my YouTube channel. Anybody on here, please feel free to go visit it at your leisure. I'm in the process of getting ready to post my next video as soon as I have to record it first, but I'm getting my PowerPoint finalized.
That's really called being in the process, right?
Yeah, right. No, but they're always relevant and real world topics and things that come up regularly in my practice. I try to relate it to what I'm seeing happening over and over and over again. So,
okay. Yep. And 4 o'clock Lover also wanted to know how to find you. And I posted his YouTube channel in the chat, which again, the videos that Andrew's doing are they're very detailed, very dense. And sometimes, you want to, look at them and stop, save it and come back to it. But it's a lot of very, very meaty information. Yes. So especially the one about hearing prep is really, really good.
Right.
Okay. Tasha Birmingham has been doing disability law for a year, trying the best I can. Well,
welcome aboard.
Welcome to the practice area. I know it can be a bit of a challenge, and I know a lot of people reach out to me. I'm sure Andrew would feel the same way. If you have questions, reach out to either one of us.
I love mentoring people, and I mean that very sincerely. I usually have at least 6 or 7 active mentees per year. I didn't have that benefit 20 years ago when I started doing this. NASCAR wasn't doing an official mentoring program. I learned through the School of Hard Knocks more than anything, and I taught myself a lot. But always happy to pass on knowledge and experience. Never hesitate
the same way. I mean, there's enough good cases out there. And the nice thing about this practice area, the people in NASCAR, for example, in Nader, and some of these other, there's another one now, but they are usually pretty willing to help. And people, it's not like personal injury where it gets really kind of nasty. I mean, no one case is, the most an attorney is going to earn on a hearing case is $9,200,
right?
25% contingency. So it's not like you're fighting over $1 million case, and if somebody called me and asked about a case, I'm going to tell them this is what I would do. This is how I would approach it.
Right.
Because, we're all in the same boat. We want our clients to get approved. And if we can't do it, then somebody, who can, you want to help them as much as you can. So I feel the same way about that.
Absolutely.
Okay. Blessed be. Well, we'll take all the blessings we can get.
We need them sometimes.
Yeah, we need them sometimes. Okay. Warm greetings. Well, it's hopefully it'll be warmer soon. That's good.
I was just going to say, I don't know what the weather's like down your way. It's starting to warm up finally. We're not getting as much snow as we got last month. But
well, we were supposed to have some snow about 3 weeks ago. It didn't happen, but we've had, I'm in Atlanta, and which is obviously in the South, and normally our winters usually started getting cold in January. We'll get low 40s, high 30s, maybe freezing. We've had 18, wind chill of 5. It's been just and I'm a tennis player, and so I'm the captain of my team, so I'm supposed to be playing these matches on Sundays, and it'll be 25 degrees, and of course nobody can play. It's too cold, so I try to have to get them rescheduled during the week. It's been just a real cold winter. So
fun time.
I will be ready for this to be over.
You and me both.
Okay. No problem about the spelling. Believe me,
I'm good. I've gotten a lot worse. Don't worry. Sandler versus Sindler. It's all good.
Yeah. Okay. Okay. Here, let's see here. All right, Karen, you started your question. Does SS always send you probably you're asking to a consultative evaluation?
Yeah, that's
not always, but many of the time, not always.
Yeah.
Okay. All right, this is a good question. Tasha, who's been doing this for a little while, is asking, why is it difficult to get a treating source statement
Mhm.
from a treating doctor or a medical? I think you really mean medical source statement,
Yeah,
source
right.
statement from a treating
That's
doctor.
probably what it is.
My take on it is that some doctors, don't want to get involved because they, like I said before, they think that by helping you with disability, you're buying into the notion you're disabled, or they want you to have the attitude you're not disabled. I think some doctors are gun shy because they've been subpoenaed before and not gotten paid to testify at hearings, not realizing post-grad doesn't really work that way. And some just because, the practice of medicine has changed. There's so many papers they have to fill out and so much stuff for insurance companies that to fill out additional paperwork, they just don't want to do it, unless you offer to pay them. So that's my reasoning. I don't. Do you have any?
I pretty much piggyback right off of that. The only thing I will tell a lot of my clients is I think certain doctors are reluctant because I think they're fearful that it means they're going to get pulled into some kind of legal matter, not realizing that Social Security claims aren't legal matters in the same sense that a car accident or workers' comp might be. And there's never going to come a point in time where they're going to be forced to testify, because their written statements and opinions and their records themselves are generally more than sufficient. And I would never ask any such doctor to testify unless I was willing to compensate them for their time, and B, they're willing to do it without without it being an imposition to them and to their practice. I know we have a colleague that actually, and he's talked to me about this directly. He may have even given a presentation on it, about actually having doctors do recorded depositions, which usually only last 10 to 15 minutes because they're not adversarial. It's just him getting a court reporter and asking the treating doctor various questions under oath about his own patient / the attorney's client, basically to get an opinion on record. And he said sometimes the real genius of it is these ALJs, who don't always feel like true actual courtroom judges, get to be made to feel like they are when he actually goes through a formal process of like moving to admit that evidence into the record and submitting it like an actual formal, professional looking transcript versus what he sees every day. And sometimes that's enough to sway that's somewhat more
interesting psychology. That's cool.
Yep. I haven't tried it yet, but I'm looking into it.
All right, so Christy is taking me to task because I made a little fun of her screen name, 4 o'clock lover. She goes, the name of the handle is your favorite flower. So Christy, I was just joking with you. I'm not, I get some really interesting handles on the YouTube channel.
Sure.
Yeah. And so I just try to have a little fun with it. So I wasn't doing anything. All right, Hazel says, can you cover Mississippi? Yeah, absolutely. I mean,
not only that, but I actually currently have a couple of Mississippi clients as we speak, one of which is at the hearing level. So that's going to be interesting. Yeah, we both of us can cover anywhere in the country. You don't have to be licensed in any specific state.
Although, I've had a couple of situations recently where I had clients out of the country. I have a client in Germany. They will not hold a hearing unless you're in the physical United States.
I haven't had that happen, but I have had clients that have gone out of the country either for an extended period or permanently relocated. But haven't encountered it in that way yet. So that's good.
No, I've got one that my client's in Germany. She was here, couldn't afford to live here, went back. Her family's there. And we had a hearing scheduled, and the judge calls me before the hearing and says, where's your client? I said, she's in Germany standing by, can't hold the hearing. There was some new provision, some sort of something in the palms or whatever they added to it, and it specifically says for some reason you can't be out of the United States. Whereas in the past, I had a client in Vietnam, I had a client in Great Britain, France. I mean, it shouldn't make a difference.
No, I would agree, especially since we're doing them remotely now. I don't.
I know. All right, Hakasad, who's a regular here, is 6 months between visit. Okay, so basically what he's asking is, if you go to the doctor, you only go every 6 months, maybe because you can't afford it, maybe because the doctor's can't do anything for you. You're kind of at maximum medical improvement.
Palliative care, it sounds like. And it's I'll summarize it very simply: quality over quantity, as far as I'm concerned. Don't make doctor's appointments for the sake of making them if it's just the same thing over and over again. Go as the doctor guides you to, go as you feel you need to, even if it's the same thing time and time again, you're not getting any better, you're not getting any new treatment, but you're still maintaining. That's what's important. And there is still consistency. If you're just going twice a year, that's better than going once or none.
Yeah, I agree. But I think, you need to probably go at least twice a year. I mean, I think if
that
you
would
go
make
once
sense.
a year, once every 2 years, that's a bit of a problem.
Right.
Cynthia, we just got time for a couple more. Cynthia says, right, this is a very good question. She doesn't like to take pain medications, which a lot of people don't, because it makes them feel really bad. They get constipated. There's a lot of reasons not to take pain medications. They could, they'll take Tylenol, they'll take Advil over the counter. Is that a problem? You've been prescribed medications, hydrocodone, oxycodone, but you don't want to take them because it makes you feel so bad. And you're taking, over the counter. Is that a problem?
So I'll tell you first a really quick personal story. When I was in my mid-20s, I had a horrible herniated disc in my low back, and it wasn't from any specific event. It was from just a long time of driving in a very uncomfortable low-to-the-ground sports car, long drives, really took a toll on me, young age in my career. And I ended up in the ER. They gave me some kind of injection at the moment, not an epidural. I think it was just a pain injection. And they prescribed me, I believe it was hydrocodone. It wasn't oxycodone. I took it one time. It was the most terrifying feeling of how it knocked me out. And I literally felt like I was on true drugs, even though it was, I mean, it's a controlled substance, but still, I will never do it again. So I commend you if that's your approach, or I hope you didn't have the kind of experience I did. But more to the point, I think what's relevant, particularly for the realm of a disability claim, they don't want to see people just popping pain pills, especially the kind that are as strong as those that are going to, constantly knock you out or cause other types of unwanted side effects. They obviously want to see that you're following what the doctors are recommending. And I don't think doctors, even pain management, are not necessarily that quick to say, just pop pill after pill after pill and go about your way. I mean, for me personally, if I have any kind of pain situation, whether it's my back acting up, which hasn't happened in many years, thank God, or something else, I don't want to just treat the pain. I want to treat the source of the pain and correct it. So for me, I like that you're indicating muscle relaxers as a go-to for you, because that's not only muscle relaxers, but anti-inflammatories, like meloxicam is one of my main go-tos, because it actually fixes the problem. It doesn't just mask the pain. Hydrocodone does just that, and then gives me all those unwanted side effects, which certainly don't allow me to function. And honestly, the only clients of mine that are ever regularly doing that typically are the ones that have the level and the type of pain that just won't quit, and they can't get through a day comfortably because they're constantly at the 7, 8, 9, 10 levels of pain. I mean, they don't want to live in the ER either, but there's not much else they can do. And obviously that in a situation like that, that's certainly going to help their cause for a disability claim. But I've never seen a situation where a judge or a decision maker is going to say, well, you're not taking heavy duty painkillers, so your pain must not be that severe. Therefore, we don't think your condition is severe enough to say you're disabled and not capable of working.
But you do have to explain it. I think.
No. Very much so. And if it's for personal preference reasons, religious reasons, whatever, those are valid.
Yeah.
And pain medications, like I said, I think at most they mask the pain. They don't get to the root of the problem. So that's why I don't feel overall like decision makers are going to hold it against you that you're not taking those kind of medications for whatever the reason.
All right, couple more questions here. I was approved at SSDI at age 56. Will I get a review in 5 to 7 years? Probably not. I mean,
I wouldn't.
At that age, I wouldn't worry about it.
Yeah.
All right. I want to. Okay. Hadn't had this question before. I want a low, 5-figure bingo jackpot at a casino.
Congratulations.
Yeah, congratulations. Did you have? The real question is, did you have a system you can share with us offline? How to do that? Okay. Assuming you don't. I'm drawing SSD. Do I have to report my winnings? No, I don't think so, because that's not earned income.
Right.
If it's SSI, you got a problem. But
yes.
Okay.
That's a resource.
Is there any way to recommend a particular doctor for CE? I mean, you can ask the judge for a specialist, but they're not obligated to give you.
Right.
So
And in some instances, you can even ask if they're willing to, and your own doctor's willing to have your doctor complete the CE according to Social Security's specifications and fill out their forms. I haven't had it happen yet successfully. I've tried it a couple times, but a lot of different moving parts have to work together the right way.
Yeah. Yeah. Okay. So let's see. We're trying to get one more here. Let's see. Okay, this one we can answer quickly. They were found fully favorable based on reviewing the file. Yes, it's called an on the record. They will do that. I've had a couple the last 3 months. I've had 2 or 3 of them, which is great. And they will, in fact, ironically, one of my on the records was our favorite judge from down here. I about fell off my chair. He gave me an on the record on occasion.
Yeah, I can imagine.
Okay. Are you allowed to record an ME or a CE, rather consultative? I don't know. It's a good question. Can you record? You said there's nothing that says you can't bring somebody with you. Can you?
I do get this question a lot from clients. So my quick answer to it is very simple. Number one, the official rule goes by what state you're in, whether it's a one-party or two-party consent state. But even if you're in a one-party consent state, which Maryland is not, Maryland's a two-party consent. So I know my Maryland clients can't, even if they want to. But I'm also very hesitant to ever suggest any of my clients doing that if for no other reason than HIPAA concerns. Even though it's not a treating doctor that you're seeing, and even though it's not for the purpose of treatment, I'm just very, very weary about having them even secretly just hit a record button on their phone to do an audio recording. I think it's a slippery slope. So I'm not a huge fan. If you have that second person with you and you can either complete a questionnaire, like if an attorney like me has one to provide, or even just take your own notes of what did and didn't happen, how long you were in the exam room, that should work just as well. And you can always put together some kind of affidavit at a later time if needed. It doesn't have to be a prescribed form like what I use in my practice. There's different ways to go about it.
Okay. All right. So here's somebody with very good taste that says, I'm a rock star. I can't sing or play instruments, but I will appreciate that. And we'll kind of leave it with this one. Thank you, Jonathan and Andrew, for sharing your experiences.
Thank you for allowing us.
We both enjoy talking about this stuff because it's really, we're sort of passionate about it. I mean, this is, nobody gets rich doing Social Security disability. I mean, you make a nice living, but, this is one of these things where, there is a feeling of gratitude when you,
that's the rich that matters.
So what?
At the end of every single day.
Yeah.
When I look at myself in the mirror, when I face my wife and my children, and I know I've made such differences in the people's lives that I'm helping, I feel like the richest man on earth. I really, and I mean that as sincerely as I can possibly say it. That's why I got into this work all those years ago. That's why I will do it until I don't have a breath in me. And I absolutely love it. And I will do it as long as my iron constitution will allow me to.
There you go. Okay. Well, we'll end it with that. That was great. Thank you very much for joining me, and everybody. We'll be back hopefully next week, next Wednesday at same bat time, same bat channel. Andrew, hold on for 1 second. But everybody have a great rest of your day, rest of February. We'll see you in March next week.
Can't believe it.